Welcome to the 1515, brought to you by the regulatory legal experts at the Maples Group. Here, you will learn more about the latest developments in the regulatory laws of the Cayman Islands on the 15th day of every month.
Hello everybody and welcome to our 1515 podcast. My name is Patrick Head and I'm a partner in the regulatory services team here at the Maples Group. Joining me today is fellow regulatory partner Tim Dawson, regulatory associate Nikki Wood, and guest speaker Michelle Bailey from Maples FS Group. In this June edition, we will cover the latest developments in regulatory laws that have taken place in Cayman since the May episode. Please note that the contents of this podcast do not constitute legal advice and should be taken as a general update only. Before we get going, just some housekeeping to cover. If listening in from your usual podcast app, you'll find our resource documents and speaker information in the description. And if you've clicked on the media player link sent via email, you will find this information in the notes section. Last but not least, don't forget to subscribe on Apple Podcasts or Spotify. Now let's get started. Michelle, thanks very much for joining us to talk about some FATCA and CRS updates.
Hi there. Thank you for having me on this month's 1515. I'd like to take the opportunity this time around to share with the audience some information in relation to what we've been seeing from the DITC, as well as some general FATCA and CRS reminders. We are seeing the DITC continuing to be very active and continuing to compare entities registered on the DITC portal with various lists, including the IRS's GIN list, as well as lists of CIMA regulated entities and the general registry. And they're issuing missing registration notices if entities have not been registered. Some of these may relate to timing differences where businesses have not yet commenced, which just really requires a response to the DITC to explain. But we are seeing the latest notices have had particular focus on investment managers, which are actually required to register even if they have no financial accounts. And we're also seeing notices in relation to segregated portfolio companies and umbrella trusts. Typically, that's where registration has actually been done at the segregated portfolio or series trust level, and there's no link to the actual SPC or umbrella trust. Where that's the case, it simply requires a link to be added, and the PPOC or secondary user can go in and submit an FI change form to link the appropriate SPC or umbrella trust. We are now also seeing breach notices coming out of the DITC, which are follow-up of previous reminder notices where action has not been taken, and they are significant penalties, with many including more than one breach of the CRS regulations. The payment of the penalty is required as well as rectification of the breach. In terms of general reminders, just another reminder in relation to ongoing due diligence of new account holders is required to be completed at the time of onboarding, or if not able to be completed at that time, within 90 days. Accounts should be closed or frozen if the due diligence has not been completed, and no payments should actually be made to those investors until the outstanding items have been cleared. At the very least, FIs should make sure that this has been completed before reporting is due. In relation to pre-existing account holders, when FATCA and CRS was first brought in, there was a transition period for pre-existing account holders where TINs were not required if they were not on file. However, that period is now passed, and there is an expectation, both for FATCA and for CRS purposes, that the FI follow up for any missing TINs. To the extent that they're not available for FATCA purposes, the IRS has issued a notice specifying 8 different replacement TINs that should be used in the place of the TIN for a reportable US person to identify the reason for not having that TIN. One such example is a set of 9 twos, which is representative where the situation is it's a pre-existing individual account with only US indicia being the place of birth in the US. The DITC issued a notice in March 2024 to clarify that a date of birth is required to be obtained for CRS individual reportable account holders, even though it appears to be an optional field in the actual XML report. Their view is that their documentation is required to be obtained for AML purposes and therefore should be available and included in CRS reporting. One additional point of note when completing due diligence on account holders is that self-certification forms should be obtained for all account holders, including those that are reporting financial institutions themselves. The Jersey Authority issued a notice earlier this year which reflects the OECD's view and also the DITC's view that validating a GIN to the IRS website is not sufficient to accept that an entity is an RFI. And as has become evident over time, the reason for that is that many entities were obtaining a GIN but were not doing any further compliance or reporting. So reliance cannot solely be placed on the IRS GIN list. Due diligence procedures should be carried out fully and reasonableness checks conducted of the self-certification forms against all documents collected in account opening, as well as against publicly available information. It should be noted that Jersey recently updated their list of reportable jurisdictions to add Jamaica, Kenya, New Caledonia and Thailand for 2023 reporting. But as that's due this month, they have indicated that reporting for 2023 for the newly added jurisdictions is acceptable to be on a best efforts basis. For 2024, it will be required. And one final point to be aware of is just in relation to the timing of registration compared to reporting and where the DITC is likely to require explanations. Firstly, as DITC has been known to issue missing reporting notices for entities registered on the portal before the end of April, but not filing in relation to the previous year. So if you have an entity that is not going to be filing in relation to 2023 because they did not actually become a financial institution until 2024, but they were registered prior to the 30th of April deadline, then there may be a notice that comes out of missing reporting that would simply require a response of explanation to the DITC. Some entities that may be the same situation, but they choose to actually file 2023 returns and compliance forms, but by way of a nil report, a nil declaration, and then with no account holders and a zero NAV in the compliance form, that may also result in the DITC querying it. And again, it will just require an explanation as to when the business actually commenced. My final point is really just in relation to the upcoming deadline for Cayman. So a reminder that 31 July is going to be fast upon us. So get your reporting completed as soon as possible. And that's it from me. Thanks, Pat.
Thanks very much, Shell. That's a really comprehensive kind of rundown there of some of the most recent issues that we're seeing. And I sort of echo your comments around the fact clients should pay attention to these points. Certainly do reach out to us at the Maples Regulatory Group. We're very happy to assist with any questions if you do receive a notification from the DITC. Moving on, Nikki, if I can bring you in now to the discussion. I understand CIMA have just recently issued the latest round of AML surveys, in particular for receiver-registered persons and other regulated entities.
Yes, that's right, Pat. Thank you. The Cayman Islands Monetary Authority recently circulated its annual anti-money laundering, terrorist financing, proliferation fining and sanctions anti-money laundering questionnaire. This is really to ensure their risk assessment of certain industries and to assist the Cayman Islands Monetary Authority with their supervision of regulated financial services providers. All entities in the regulated sector, other than mutual funds and private funds, would have been sent a link and asked to complete the AML survey. The link could go to the AML officer, it could go to the registered office, or it could go to certain people that the Cayman Islands Monetary Authority has on records as to being a contact point for the entity. I'd say the first item would be to make sure that you can get access to that link. If you can't get access to that link, then email amlsurveys@cima.ky, that's with an S, to ask them to send a copy of the link to you. The submission deadline is the 30th of July for most regulated entities, so registered persons, trust corporate service providers, banks and mutual fund administrators. And then insurance is later in the year on the 30th of September. The AML survey questionnaire is quite lengthy. It has around 500 questions in. Where Maples has been appointed as the anti-money laundering compliance officer, they will have certain of those responses on record. However, the most of the responses would have to be completed by the business as they are business specific. If you require assistance, we can provide an annotated copy of the AML survey, which provides Maples and Calder's guidance on it from the law firm, and the reporting schedule and the AML survey guide is available on CIMA's website. Please, as I say, make sure you have a copy of the portal link so that you can access the portal. Probably keep it on an Excel spreadsheet separately so they can then transpose the data into the portal. And Maples and Calder is available to give you a copy of an annotated spreadsheet should you wish.
Thanks very much, Nikki. Yeah, obviously it's a very comprehensive survey given the number of questions involved. So again, for any listeners out there who received this and do require assistance, either feel free to reach out to Maples Regulatory Group if you're an existing client, or to your usual Maples contact, and we can then assist from there. Tim, I believe that CIMA have also, in the last month or two, issued a new rule and statement of guidance on market conduct, which in particular applies to trust and corporate service providers as well as company managers. Are you able to give us a rundown of that?
Yeah, so this rule and statement of guidance is basically updating what was previously simply a statement of guidance. The distinction there is that rules are supposed to be directly enforceable, whereas guidance is supposed to be merely guidance. I have to say that in practice, when it's come to inspections, CIMA have always historically treated the items within statements of guidance as being obligatory, but nevertheless, the most salient points are now rules. There have been some updates which to a degree are kind of consistent with updates made to the internal controls rule last year. In particular, there's a real focus on segregation of client money. I'm not going to go into a lot of detail because anyone who is working in the corporate services or trust sector needs to be fully cognizant of these new rules. And I should probably just say at this point that they come into effect in November. So plenty of time for you to read, but something you need to be fully on top of. Need to segregate client money, but CIMA did listen to industry when industry pointed out that in a lot of cases, the corporate services providers are actually a conduit for payment of fees to regulatory authorities in the Cayman Islands. So for instance, where corporate services providers, whether under the Company Managers Law or Banks and Trust Companies Act, are acting as registered office providers, they will be paying a large amount of money over to the authorities in payment of annual fees. But it is accepted that in those cases, there isn't a need to set up specific client money accounts. So that's really important as a practical matter. Nevertheless, if you are acting in a kind of quote-unquote true trust capacity and you are dealing with client money, then there are fairly acute client segregation rules. This is as distinct from client assets. The client asset segregation rules are somewhat different to client money. So the distinction being broadly as between cash and perhaps securities or other kind of assets which you might be holding on trust. There's also rules with respect to where a Cayman regulated entity is acting as a nominee. There now needs to be a full-blown nominee agreement in place. There's also rules with respect to where there's a counterparty acting as trustee in a fiduciary relationship. So in other words, where a Cayman regulated entity has someone else acting as the custodian of assets, there are rules dictating what you need to have in place to ensure that everything is compliant. So, everything's pretty sensible. It's just that those who are working within this industry need to be aware of these changes and ensure that their systems and controls reflect them before November.
Thanks very much for that, Tim. That just also brings me on to CIMA also have just recently issued a new policy paper on VASPs, specifically with respect to the registration and licensing requirements. This came out in May, and it obviously reflects the new turning on of the licensing regime for a VASP in terms of operating a platform and also custodial entities, but also more broadly, steps through in clearer detail what is required as part of an application for a VASP registration and or license. And it goes into some detail, which I think is actually quite helpful and will hopefully facilitate complete applications being provided with all of the information that CIMA needs in that regard. I mean, it sort of steps through the normal fitness and propriety points, but also touches on having fulsome business plans, etc. in place, and then goes more into sort of operational controls and points and AML mitigating measures and controls that an entity would have. So if anybody is contemplating a VASP registration in the jurisdiction, I would say firstly log on to CIMA's website. Under the regulated sectors, you'll see the VASP drop-down box, and then head for the latest policy documentation and read through that in detail. It's very helpful. Tim, I believe there's just an update there from the FRA with respect to the filing of SARs and some new guidance on that.
Yes, thanks, Pat. The FRA does publish guidance on how to prepare and submit high-quality suspicious activity reports, and their latest amendment was made on the 28th of May. The amendments themselves are fairly limited insofar as they basically rename Cayman laws. There is some detail on how to file SARs, in other words. I mean, the various ways you can do it. If you're not signed up to the FRA's AML live reporting portal, then you would probably file a SAR by email, and there are instructions on how to do that. I mean, really the key message is, particularly for our listeners who are not resident in the Cayman Islands but are acting in an MLRO capacity, is that this document exists. It is quite useful for when you're looking to put together a SAR. So if you weren't aware of its existence, please do go and have a look at it because it's quite a good tool.
Thanks so much for that, Tim. So that's it for today's episode. Thank you very much to all of our listeners for listening and subscribing, and enjoy the rest of June.